Artificial Intelligence and Rule of Law. This is third session of the 3 sessions. This is session 11 of this course. To do a recap, in the last session, that's the second session of 3, we discussed about the emerging relationship with technology and area of practice of law. We stressed the need for AI literacy and argued that defining AI process is difficult and AI evolved since 1950s. Further, we touched upon rule of law in the context of power of technologies. So, in the 2 previous sessions, we broadly touched upon many themes on AI and the relation between rule of law. In this session, we will look at some of the interesting aspects and themes which will deepen this discussion and also help us to understand them in a better way. To begin with, how do we look at AI? AI being a very emerging technology, it has created expectations, hype, lots of hope and then fears. But the way people look at technology has also changed. And then technology also undergoes change by popular culture, people's expectations and all. This we know very well the way public responds to AI, particularly the younger generation. AI, if we look at it, when it was started in the mid-50s in the Dartmouth College in the 1951 workshop, it had got a very limited objective. Automata theory, neural nets and then intelligence. But it at that time got its inspiration or took ideas from 3 or 4 major disciplines: neuroscience, mathematics and information theory. But today, AI is not something that was of the 1950 vintage. Today, AI is something that is totally different, although the objectives remain the same, although the goal remains the same. Today's AI is very different. And today, AI is something that can easily be put into one conventional box. AI is not neurotechnology, AI is not information technology, AI is not mathematics, AI is not that. AI is what you would call as a techno science, not a simple science or not an applied science also. So in that context, AI, when it is being developed with the idea of mimicking or duplicating human intelligence and capacity, it goes in a different direction. So we need to put AI in the social context, in the social economic context, and more importantly, as a society, we need to be bothered about its long-term impacts. For the simple reason, this is a technology that in more than one sense concerned with our human brain, are concerned with our human mind and the way we understand the world and the way we interact with the world and the way we want to do things by ourselves, in the sense that intelligence is very human. So when we look at that, there is a paradigm shift in AI itself. AI from 1950s and then changes have happened in the last 2 decades so much. But when AI is transported into criminal justice, it can happen in many ways, like we have discussed all these pre-trial and all. In particular, AI in the US criminal system has been very controversial. The pre-trial risk assessment algorithms used for bail and sentencing have been challenged. We will take a very specific case of State and Loomis. We will see this case in later detail earlier. So the defendants were using Compass algorithmic risk assessment, which we saw. When this case went all the way to Wisconsin Supreme Court, it was challenged on the council of lot of legal grounds by the American Civil Union. The Supreme Court of the Wisconsin state upheld the use of Compass, but Compass assesses variables like criminal involvement, social exclusion. Then there is another system risk indication AI-based software. It was used to identify fraud in low-income communities in Netherlands. This again is something very similar to which we saw earlier as to whether people are entitled for unemployment benefits or social security benefits. So this is the way AI systems are being put into in criminal justice system. But let us also bear in mind that few applications here and there cannot be simply taken as exceptions, because the pervasive nature of AI to deal with the problems is likely to replicate the same issues and same problems elsewhere also if they were not addressed. But as we saw in the previous class, particularly towards the end, we need to understand technology as power. On the other hand, we also saw that rule of law is not something that is frozen in time or etched in stone. It is a political ideal mechanism for abuse of power. It is also something that society upholds like welfare human rights. So it is worth protecting despite susceptibility to political abuse, in the sense that the idea of rule of law can be politically abused by an authoritarian government which can subvert the rule of law in different ways without actually subverting it in the sense that by abolishing institutions. It won't abolish institutions. Rather, it will make the institutions amenable to it and then still claim it is rule of law prevails. So the elusiveness of rule of law itself is something we should be very careful about instead of idealizing about it. And we should also think that however much problematic, however much idealistic and utopian rule of law is, it is worth protecting despite all these things. In the sense that time and again rule of law we need to focus on for the simple reason it is an ideal not only to be upheld but also to be lived with and lived upon. So when such an ideal is being to be impacted by modern technologies, we need to be more control about it, and particularly when AI and machine learning and the automated decision making through algorithms, when they challenge traditional ideals of rule of law, we need to be really bothered about it. So one concern is that human agency is the cornerstone of society, and then AI potentially can affect it or it can be harmful to human flourishing, particularly human agency. So there are future challenges when rule of law confronts the power of technology, not the technology per se, but the power of technology, because technology in one sense is not a tool, it is also an embodiment of power. In other sense, artifacts have their own politics, artifacts have their own power, and more importantly, technoscience relies on the power of technology not only to promote itself and then to make people look at it in awe and wonder. So when we say all this, we also need to look into some very interesting things about AI. First of all, we said AI has evolved. Okay, rule of law has also evolved. Good. And then we need to put one more thing here. The sense that a precise definition of AI that captures everything about AI is simply impossible. It is not that AI is an amoeba that changes its size, or it's not that AI is something that always changes its colors. No, it is not that. The problem is the AI can be looked at, can be defined and can be developed in different ways. According to Alan Turing Institute, given by definition is that AI systems perform cognitive perceptual functions. So they focus on that aspect, which earlier preserved or reserved for human thinking, judging and reasoning. So from that perspective, AI is a system which performs cognitive function, which we thought only humans were capable of doing. The UUAI Act defines AI differently, but then keep in mind the UUAI Act definition of AI is derived from the OECD definition of AI, and then the OECD definition of AI is again a well accepted, widely accepted definition, particularly in the context of law. So AI Act of the EU defines as that is software developed with machine learning, logic and statistical approaches. So it takes a very technical, functional approach towards defining AI, and then it says it generates outputs and then it predicts, it recommends and decisions. So it looks at AI systems, it does not define AI per se. Then Irish Council on Civil Liberties, when they wanted to respond to the way AI should be defined, then they said don't bring in human defined objectives over there. Rather, make that as AI defined objectives and intermediate purposes. This is the debate over how to define AI in the context of UAI Act, which we need not get into greater detail now. But the current generation of AI definition is not the one which was there earlier. We are not talking here in terms of mere consciousness or the cognitive capacity. Here we are talking in terms of the machine learning ideas from which this intelligence is being derived and then trained and was used, and then it is again maybe with human biases. So there is a huge problem in defining AI precisely for the simple reason AI means different things to different people, and then technically, scientifically, and in every other sense, AI is something that cannot be defined exactly this is what and this is exactly what AI is not. So that sort of benchmarking or that sort of clear cut categorization is not possible with AI. The Council of Europe, which was formed in 1948, is a body consistent of states in the Europe as member states, and then of course there are others who are also associated with that. It is a body that has been concerned with human rights right from its inception, partially on account of the Europe's disastrous experience with fascism and Hitler, and partially on account of the European concern about human rights, human freedom, human flourishing, right to expression, and fundamental values. It has always been some one organization in the forefront in trying to understand how technology impacts rights, how technology impacts liberties, particularly how technology can do good or can harm human capacity and then human flourishing and particularly human rights. So the Council of Europe is also the first body to identify privacy as a major concern way back much before people even thought in terms of privacy and technology and then how privacy can be harmed with technology. And then the GDPR, its origins can be traced to the work of Council of Europe's work on privacy. So the Council of Europe had a committee on AI, and then that committee came up with a report, they debated it, then they made some recommendations on AI, and what is the outcome we will discuss later in one of the sessions. So they look at AI as a social technical system, very different from what the OECD has defined or very different from any other definition. And then they say it's a social technical system influenced by initial design, data input, environment and human values. So Council of Europe looking at AI as a social technical systems also says it was potential freeing up time for long-term issues, it can make publicity authorities efficient, identifying public needs, contributing to policy development. It recognizes the good potential of AI, no doubt about it. But when we say rule of law, we need to look at independent judiciary, fair trial to the accused, and then access to justice. So, rule of judiciary and rule of law is much more than principle of equality of arms. Equality of arms that each party in a legal dispute has equal opportunity to present the case, or no case is decided without hearing the other party or other parties. So it is not just there is a case decision being taken without a defendant, or you apply or you file a petition, case is being decided. So the equality of arms principle says there are two parties at least to any dispute, particularly when a dispute before a court. Then the European Convention on Human Rights, Article 6 guarantees right to free trial, free and public hearing within a reasonable trial, hearing by an independent impartial tribunal established by law. This is again the core idea of rule of law. Why are we talking about it now? Because some of these ideas like free trial, equality of arms principles may be impacted by AI systems, particularly algorithmic decision making and the black boxes which decide as to whether a person should be entitled for welfare or whether a person can be released on bail. How this happens and why this is important, we will see now. AI systems are likely to generate biased recommendations. So to understand that, judiciary should also understand how AI systems work. They need to have a minimal understanding, if not a complete understanding of the AI processes. And then we should also ensure that there is a judicial oversight and accountability for AI systems. On one hand, AI can analyze vast databases more efficiently. Legal decision making, which has been reserved for skilled lawyers and jurists, is now being extended to AI. So we need to look into the algorithmic thought process in the AI that needs to be scrutinized. Of course, the bias and transparency are always there. So if you are going to use AI in judicial making, then these are the concerns we need to primarily address with, irrespective of talking of plus and minus aspects of AI. And then there should be a clear cut distinction between use of AI in judicial matters in certain sectors and not in certain sectors. For example, civil, commercial, administrative matters, use of AI versus use of AI indiscriminately in criminal matters, we need to be very wary of. So use of AI per se is not problematic. Problematic is that in which matters, how it is being used, and then what is the way the judicial system is being impacted with that, and more importantly, how the judicial system's independence and then its guarantee of access to free, fair trial, and then the equality of arms principle, and then those norms are not being violated by AI. So AI, whether it aids a judge in taking a decision or whether it itself aids a judgment and then passes orders, we need to keep these things in mind. Then, when it comes to predictive policing, which we have discussed, the UUAI Act puts this as a high risk classification. So, under that, any system that can profile individuals and areas means locations, pin code, and other things, are classified as high risk systems. So, any system that determines likelihood of someone committing the crime again will be classified as a high risk system. So, the UUAI Act, which we will see in detail in one of the subsequent classes, addresses some of the concerns on rule of law versus the negative impact of AI on rule of law by taking into account some of the major factors and then categorizing these applications as high risk. It is not saying that these applications are something that can be allowed. All it's saying is that these are high risk classification. The high risk classification, whether AI Act allows them to be developed and deployed or not, we will see in detail, because the AI Act classifies systems based on its own risk assessment, and then that risk assessment is not a mere technical risk assessment. That risk assessment also takes into account the potential for human rights violation, the potential for human liberty being negatively impacted, and the more importantly, the potential for discrimination becoming part and parcel of that. So the risk here is not just a technical risk, or the risk here is not the physical risk, or risk here is not the harm that AI systems can do to an individual or to a specific unit. It is a broader idea of risk. Again, based on the idea of human rights have to be defended and protected. Now, if we take this into account and then look at the threat that can have come to rule of law principle from AI, some of the rule of law principles like presumption of innocence, equality before law, and then non-discrimination can be violated by AI, because as we saw in at least 3-4 cases in our previous sessions, the one on AVAS, the one on Compass, the other ones which we saw, they all repeatedly tell the question of equality of law does not apply there. They're prima facie discriminatory. And then there is no question of presumption of innocence. In the sense that the AI system does not presume that there is innocence, it simply assesses. So this is some of the things which we need to look into. So when the UAI Act was being framed and debated, there were a whole lot of debates and discussions about human rights implications, about the AI systems that can have potential negative direct and indirect implications for rule of law. So many of the people who were concerned, they wrote a petition, they issued a statement on the UAI Act that, look, UAI Act should prima facie upfront prohibit certain applications of AI systems, however much they may appear to be beneficial and however much they may appear to be something that the society may need. So the idea here is that predictive policing and profiling have to be categorized under some idea of risk to human rights, to human liberty, and then rights of the people, rather than looking at merely in terms of technical issues. So the question here again becomes, how do we deal with the technological advancements, the potential, and then the various threats, and then the various negative impacts which we discussed? What is the way out? Is there a way out? Can anything be done about it? Some of these things can be addressed in a typical law and technology perspective, where you put regulation at the core, and then you say that regulating a technology is necessary not only to promote innovation but also for the society, so that society is not harmed. And one of the approaches in technology regulation is that harmonization is a better approach than a fragmented approach of each country devising its own standards, technological norms, and then regulatory parameters. So harmonization is one way to solve this problem, when if many countries agree that AI systems should not negatively impact rule of law in their own country, or they try identify the core values or core principles which AI systems should not violate even they are being put to use, it is possible that there can be some sort of harmonization in dealing with AI systems in law and justice. So, importance of upholding the rule of law in AI is very important if we talk in terms of harmonizing AI regulations. But if we see that the fundamental problem is that the intrinsic issue with AI technology, it understands, we are not able to understand how it works. So the lack of transparency can again be addressed through regulations. The EU AI Act tries to address it. Various regulatory orders of different countries or the regulatory regimes of different countries try to order them in different way. There is a whole lot of literature, some of that which we will discuss in subsequent classes on that. But if an AI system can really compromise or harm an effective judicial remedy to access, for example, the right to appeal. If you have an AI system that is where the matter ends, or if there is an AI system where it is decided that whether you are innocent or not, you have to pay this much fine, or whether you have evidence to prove that you are innocent, system is not going to reopen the case for you, then the effective judicial remedy is closed. So this again is a violation of rule of law. One way to address this is that don't make AI system as the final arbiter or the final decision making. Even if you do not have human on the loop, even if you do not have humans to supervise the decision, have a human or have a panel or have a forum where the decisions of the AI systems can be appealed or can be at least challenged. Then, if an AI system infringes, harms, or negates fundamental rights, there should be an accountability, there should be a procedure to challenge it. For example, if an AI system, on the basis of biased algorithms and then other things, denies bail for one person, grants bail for another person, and then the fundamental rights being violated, there should be a way to make this accountable, and more importantly, there should be ways and means to challenge it further. So the fundamental core ideas like the right not to be discriminated against, as well as the right to an effective remedy, should not be diminished or eclipsed or negated or abrogated either in part or in full by AI systems. So when we talk of harmonized regulation of AI systems, particularly in the context of AI systems being put to use in law, in justice, particularly in criminal justice, we want to enlist certain parameters or certain guidelines which are necessary. And a harmonized regulation, whether it is globally or regionally, is one solution to address that, rather than trying to address it by piecemeal looking at individual countries' solutions. Because when countries adhere to a convention or a treaty, become parties to that, it also indicates that irrespective of the way the countries may implement those conventions and treaty, there is a broad consensus that these are the core things that need to be addressed upon. And the European Council's EIA treaty does something which is very similar. We will look at it we will have an in-depth discussion on it in one of the classes. So these are some of the things which we have discussed again and again, like difficulty in determining accountability, potential accountability options, and then the implication for technological innovation, like there could be possible potential chilling effect on innovation if it's just too much on rule of law. Again, developers may not agree to develop systems if they think that accountability is going to be a burdensome. Again, accountability, liability are issues in many technologies, including nuclear technology. So these challenges in accountability have to be addressed, can be addressed in many ways, because this is something which people who have been dealing with technology regulation know well. And then technology regulation, we have enormous case studies, we have enormous case laws, principles where these things can be dealt with confidence and then with prior learning from them. So AI is not something where we are seeing things for the first time, but AI is something where we are seeing these things in a much more fundamental way, in the sense that they can be potentially antidote to rule of law. So what all we need to bring in to ensure accountability and transparency in a harmonized regulation or at a national level regulation has to be done. And the legal framework should ensure that there are rule of law principles are incorporated in that, but at the same time it should also deal with fast-paced AI development. This is a huge dilemma which we will discuss in one of the classes, particularly talking about the pacing problem in AI and law. And then we should also see that if AI systems are regularly routinely complying with rule of law principles, that will impact negative impact assessment. But then how to do it? There are ways of doing it. People have been working on it. Then there are reports to look at this issue. So you need to come up with regulatory guidelines, governance frameworks, and then the Council of Europe's focus on ethical framework for AI, particularly the framework on ethics and AI and human rights in the context of AI is very important. So at the international level, you would need policy coordination, you would need policy coherence, and then you also would need a whole lot of things that could be done to balance innovation with regulation. But balancing innovation and regulation in law and technology is not a new thing. It has been discussed, solutions have been found, however imperfect they may be. So there are precedents, there are previous examples in which AI, the problems which we think arise on account of AI, particularly in law and justice, can be addressed. So then we need to fit two things here: the rule of law, the AI technologies, and then what are we going to do in all that we have discussed? So, but we need to also do one thing, in the sense that we need to have a clear charter of what all the things we need to do. So, if we have think in terms of rule of law in AI era, we need to address accountability and digital divide. Addressing these two things will help us to address greater problems. So, where do we go in the rule of law in the AI era? Let us also understand how AI can advance rule of law is not very clear, because problem is our experience with AI itself is not even 2 or 3 decades old. But AI is becoming more and more developed, it's getting integrated so much that if not the whole idea of rule of law, we need to be fearful about. We need to be fearful about certain things so that we have some minimum safeguards built into the system so that some critical aspects of rule of law are preserved, including the right to equality, irrespective of developments in AI. Or in other words, we need to have guardrails and then other mechanisms that will function as something like, the way the train is being stopped by applying brake, or even when the thermostat stops when the temperature goes beyond a level. So we need to have some lot of guardrails and a lot of guidelines. So the point here or the problem here is that unfortunately, while globally there is a whole lot of discussion on AI regulation governance, that is not looked at from the perspective of rule of law particularly. So except the EU's AI treaty, there is no major initiative globally which addresses some of these concerns, including the impact of AI systems on human rights and personal liberty. So we need to again think beyond thinking technology as a mere tool. We need to look at technology as something that is inherently potential or negative. We need to go beyond that. And AI being an emerging technology, it cannot be thought as yet another emerging technology, but it's a technology that has its own unique features, that has got its own unique history, and more importantly, it's a technology that the only technology that is trying to mimic our intelligence. So, the rule of law in the AI era is a very serious topic. There are potential things which we need to discuss. So, where do we go from here depends upon how much importance we want to give to rule of law in the age of AI. Or are we going to compromise rule of law in the age of AI, or are we going to ensure that they are harmoniously balanced is a big question. So the discussions, the points or the examples which I gave in the last 3 sessions are based upon the literature and then the references which I am citing here. See, fundamentally this rule of law AI debate is again very recent one. It is not even 15 years old. At the same time, some of the ideas relating to algorithmic decision making, automated decision making in the context of AI, and also some of the recent debates on various things relating to AI and fundamental rights are so new, but then the concerns and fears and some of the terms of the discourse are also so old. So I am giving references to the major articles which helped me in conceptualizing and delivering these sessions, 3 sessions on rule of law and AI. But there is more in the literature, there is more to be talked about it. In fact, one can even do a 20-hour course on rule of law and AI, looking at different aspects, but that is for another occasion. And as this is an emerging theme, we have just introduced to debates and perspectives. References and additional literature can be available made on request. So with this, we come to the session 3 and the final session of AI and rule of law. The next session will be on the idea of algorithmic justice, taking forward our earlier discussion on algorithms, AI, and algorithmic decision making. Thank you.